Can someone in the back tell me whether the sound is okay? So certainly, I don't think it is because you don't react in the back. Yeah, it should be louder, right? So would it work like that? Yes, it would. It would. So we need something to put the mic on.
I think we can start. Good afternoon. Yeah, we're starting. I would say yeah, no?
Yeah, but we didn't solve the problem, actually.
Okay. We can start. Good afternoon and welcome everybody to the third plenary session of the ADiM-IntoME conference with the title The New Pact on Migration and Asylum, Implementation and Enforcement Issues. My name is Federica Passarini and I am a researcher here at the University of Tuscia. First of all, I would like to introduce our distinguished speakers. Professor Lilian Zurdi. She is professor of European Migration Law and Governance at the Law Faculty of Maastricht University and the Maastricht Center for European Law. She is currently PI of the SOFTEN project, supported by European Research Council Starting Grant, as well as WP leader in the ongoing collective Horizon Europe Ensured project. Then we have Professor Jürgen Bast. For those who yesterday were not here, he is professor of public law and European law at Justus Liebig University of Gießen. He is the spokesperson of the research group Human Rights Discourse in Migration Societies and PI of the legal research project Territoriality, Public Authority, and Human Rights, the EU's border regimes. In May and June 2025, he's also visiting professor here at the University of Tuscia. Thank you both for joining us. Professor Zurdi and Professor Bast will discuss on two major issues related to the new pact on migration and asylum, namely the impact of asylum procedures on the human rights of the migrants and asylum seekers, as well as the challenges in implementing the new pact. It is crucial to interrogate these issues at this moment, as 1 year has passed from the adoption of the pact by the Council and the European Parliament, and 1 year remains for entering into application. The adoption of the pact undoubtedly represented a historic moment in addressing migration in Europe. Indeed, during a delicate period for international relations, the member states of the European Union demonstrated their ability to reach a compromise in migration management and established the first legal framework, comprehensive legal framework addressing migration and asylum. However, the success of the pact will depend on how the rules will operate on the ground and on their implementation. This raises many questions, some of which will be addressed by our prominent speakers. So I will not take up too much of your time, and I will now hand over to Professor Zurdi, whose presentation is titled Governing Implementation Through the New Pact on Migration and Asylum. Please, the floor is yours.
Many thanks, Federica, for these kind words and for this introduction to the session, and also to Professor Mario Savino for the kind invitation, and to the entire team for an excellent organization of this conference. I've been following different discussions and they have been very stimulating. And also, Chair, I have also here a timer, but do point me when there are 5 minutes left, so that, because we are two and I don't want to go over my time. So I start with the new pact on migration and asylum. What's the new pact on migration and asylum? So it is a policy framework that was actually launched by the European Commission in September 2020, and it is underpinned by a number of legislative instruments. These were under negotiation for a number of years, almost 4 years, and they were adopted, as Federica mentioned, last spring. But unusually for regulations, most of the instruments, as you will see, are regulations. While they are already in force, they will begin to apply in 1 year time, so around most of the instruments in July 2026. And the reason why this choice was made relates also with the focus of my talk, is that for the first time there was a more serious attention to the elements of administrative implementation, of operationalization, and of human and financial implications of the policies. So there was a more serious considerations, and we will see that this is reflected in the governance architecture as well of the main building blocks of the pact. I'm not going to go through all of the instruments, just to say that both Jürgen and I will be mainly focusing on the screening regulation, on the asylum procedures regulation and return borders procedures regulation, as well as the asylum and migration management regulation, so the first 3 instruments. But of course, the pact is much richer than that. And in fact, there are also so-called related instruments to the pact instruments. So Schengen governance, the external border control governance, is also related. The legal migration acquis is related. The instruments on smuggling and trafficking, we have a new directive for trafficking, and there is actually a package under negotiation for smuggling. So just to say, there are much broader as well policy implications and linkages than the ones that we will focus on today. So I will have 2 focal points, and these will be mainly from a governance perspective, because it is impossible to go through the entire pact even in the generous time that was given to me. My first focal point will be this seamless migration process, which was one of the main goals of the pact. So there is within the pact much more a linkage between different policies, so asylum, external border control, returns policies. One can see this in different provisions, but more pronounced than in other areas. One can see this through this seamless migration process. So this is consisting of 3 stages, of which screening is the first stage, and then potentially referral to asylum procedures at the borders, and also potentially, if these come to a negative finding, to return border procedures. So screening actually is a first phase that concerns everyone, so every arrival. It complements the checks that are carried out at the EU's external borders, and it mainly is to take place for new arrivals at the external borders, but it could happen also within the territory if authorities encounter someone that they realize that they have never before been registered. So this concerns also asylum seekers at the borders. So if they are seeking protection at a border crossing point without fulfilling the entry conditions, they are also subjected to screening. So what is this screening? It's a very swift initial phase between maximum 7 days at the borders. And it consists of a preliminary check, so health, vulnerability, identification or verification of identity, and then there is a referral to the appropriate procedure. So one of the big victories of the Parliament is that this quick process will not lead to any decisive finding as to either asylum or return, because this was also at the table at the beginning, that this could have been the final decision. There can only be a referral as to the screening, but of course different elements such as identification or verification of identity can be instrumental in the next phases. So border procedures, and here Jürgen and I will be complementary because he's going to close in on their fundamental rights implications, whereas I'm going to look at them more through their governance perspective. Border procedures are a variant of accelerated asylum procedures. So until now, border procedures existed, the possibility for border procedure exists, but as I mentioned, just as a possibility for member states. One of the main, let's say, innovations of the pact is that they could become mandatory in some cases, and Jürgen will go into more details. So this means that for specific categories of asylum seekers, member states must apply border procedures. There is the possibility to exempt some groups from them, but no absolute exemption of vulnerable individuals. This is different than the current practice at border member states where vulnerable asylum seekers were exempted. And we are considering short processing deadlines, so 12 weeks or 16 in case an intra-EU relocation comes into play. Of course, this doesn't mean that the length of the period is not connected with fundamental rights implications, and Jürgen will go further on this point, so I will not insist. So my main focus is this following slide, this notion of adequate capacity. As I just mentioned, applying border procedures could become, or will become, for some groups, an obligation for member states. So first of all, this means that there was a much more serious thinking, let's say, from an implementation perspective of what this means in terms of the capacities that they should make available. And for the first time, there has been an effort to adjust these capacities according to objective indicators. So there is, first of all, an EU-wide capacity that should be made available. These are the 30,000 positions, and by that I mean at any given moment on an inflow-outflow basis. But these 30,000 places are not equally distributed among the member states. So it's not a matter of a simple division with the number of member states. There is an intricate formula to find the adequate capacities / of course, in our minds, we have to think responsibilities for member states. And of course, you can imagine that issues such as the geographic position of a member state will influence the adequate capacity that it has to make available, because among the indicators we have, for example, the number of irregular border crossings. And this depends on the geographic position of a member state. This means that border member states will need reasonably to make available more, let's say, spaces, if you want, for this swift processing at the borders. And when the capacity of a given member state is reached, but that, as I said, on an inflow-outflow basis, it can, on an intricate communication with the EU institutions, pause the mandatory processing for a number of cases. And there is also a ceiling, so a maximum per year. So at that point, only very specific categories of asylum seekers, these are those who endanger national security, will be subjected to border procedures. So this kind of rationalization in terms of objective indicators can be seen to some extent as a positive step in the sense that it could enhance mutual trust among the member states, so they have a specific pre-appointed, if you want, responsibility, which is for them, let's say, known. So it does not mean that there are obligations without end. And also there are objective indicators for them to say, okay, now my capacity is exhausted, etc., etc. But of course, it means that actually member states at the external borders have enhanced responsibilities. So this, one of the other, let's say, main goals of the pact was to enhance solidarity among the member states. So here we see that as a first starting point, the one goal, which is the seamless migration process, actually disbalances even more the solidarity deficit in terms of sharing between the member states that existed. The second point, and that I will not make, but I don't want you to consider that I am naive, is that this border processing, of course, has a very distinct also impact on the fundamental rights of migrants. I will not go further into this because our next speaker will, but I am, of course, very mindful of also this aspect of the impact of border processing. So, as I said, in terms of intra-EU sharing, we come to, even if you want, greater problems, greater issues than when we started with these mandatory border procedures. So then the question is there an innovative thinking in terms of solidarity, in terms of intra-EU sharing that could counterbalance this even more enhanced obligations for member states at the external borders? So in terms of the notorious by now Dublin system, the EU's responsibility allocation system, this in fact is retained largely in all but name. So the criteria, the hierarchic criteria for apportioning responsibility among the member states are retained with only slight amendments. So you see a new criterion that I include in the slide that will, as you can imagine, numerically affect very few asylum seekers. And any other more innovative thinking that would also integrate the agency of asylum seekers, such as meaningful links based on social or cultural considerations, are only a discretionary ground. So if this has not changed, what has changed? Why has the Commission and also the co-legislators taking our ears that there is something very new here within the new pact? So it is mainly through the solidarity aspects that are introduced and the governance mechanisms of the system that we find the novelty. So first of all, there is an understanding that already several other parallel mechanisms that are included as a structural functioning of the system, such as EU agencies, and several panels have touched upon their workings in our area, EU funds, as well as, more concerningly, even the existence of cooperation with third countries, including with the goal of externalization, are, in a way, a migration support toolbox, but still it is understood that there are possibly further elements that will need to come into play in order to counterbalance, let's say, this potential disproportionate apportioning of responsibility, and here solidarity comes in. So, two main observations. First of all, solidarity remains as a palliative solution. So rather than it being structurally embedded in the system, it is still triggered by so-called situations of pressure. So in this sense, not much has changed from the previous setup. What has changed, though, is that, first of all, solidarity is meant to be mandatory, as in that every member state needs to do something, needs to bring something on the table, and this what is also, again, apportioned based on some reasonable objective indicators, so based on a key that takes into account the GDP and the population size. But it is mandatory but flexible. So flexible meaning that what the member states could pledge, could bring on the table is either relocation, so this means intra-EU transfer of either asylum seekers or recognized beneficiaries from these member states that are under pressure to other member states, financial transfers to the EU budget, and here I am referring to money that will first join the EU budget as part of this exercise, so not drawing from the existing funds, but member states infusing the EU budget for migration and asylum with more money from their national budgets that will come into the picture as externally assigned revenues, and so-called alternative solidarity measures that could be focused on capacity building, services, facilities, etc. There is also an intricate governance system to support this, what is meant to be an annual pledging exercise, where the Commission and Council will have pivotal roles in, first of all, ascertaining pressure, then in ascertaining needs, in leading politically for the Council this process of pledging for the other member states, and in the end, in generating a specific Council decision that will, let's say, very clearly portray what those solidarity pledges will be. However, of course, a lot of questions remain open. So will there be enough political, let's say, will, and will these processes of steering and of peer pressure lead to enough, if you want, contributions to come to the table? Will there be a predominance of financial and other contributions in contradistinction to intra-EU people sharing? And if that is the case, how will this affect the member states that are under pressure? There have been already declarations. The mechanism has not been activated yet. As I said, this will begin to apply from July 2026, and during the next year there is going to be this sort of first cycle of reporting, of pledging, and several member states have already blank out stated we are not going to participate at all, for example, in intra-EU relocation, and that before the mechanism has hit the ground. So if we take a bird's eye view, and I see that I have around 5 minutes, so I'm self-controlling here, under some axis, we see that yes, there has been a distinct evolution through the pact instruments, and I only mentioned some examples. There are further examples, such as, for example, how crisis is meant to be identified and managed. We do see a greater thinking on the governance of the system, so permanent governance structures and processes, an annual migration reporting cycle, annual solidarity fora and pledging exercises. There are more structured processes to identify capacities at the border and their exhaustion, based this time more on objective indicators rather than on some self-identification of member states that can be contested by the other member states, leading into political tension, etc., etc. And there are, I haven't touched upon this in my presentation, but we can discuss about it afterwards, also structured processes to identify other than pressure, so-called crisis and force majeure, as well as concrete response mechanisms to those. We have an evolution in implementation. There is enhanced awareness, as I said already, from the fact that for the first time the EU gave the member states and itself 2 years in order to be ready to apply these instruments that will have far-reaching implications, means that they took implementation and its consequences more seriously. So there is more enhanced awareness of implementation capacities, needs, as well as solidarity needs. There is enhanced access to funding, both at the EU level, and this we have seen also the funding file for these areas grow over the different multi-annual financial frameworks, but also through this innovative process of new money, fresh money coming on the table, so through this externally assigned revenue through solidarity processes. But, and this is very important, there hasn't been a radical overhaul of the implementation design, so still it is upon the member states to be the main responsible actors to implement the policy. And there hasn't been, and we are now running through the 2021-2027 multi-annual financial framework, the same that gave us also the recovery and resilience package. So that was an innovative package, but otherwise there hasn't been a radical overhaul of the EU's multi-annual financial framework. So even if the co-legislators wanted to, they couldn't have said, okay, we pass to a compensatory logic. So the EU budget is meant to, I don't know, compensate the efforts of member states in implementing these policies. There is no political will in this sense, but even if there was, we couldn't have done it, because overall the pie that we have for these policies was the one set in 2021 until 2027. And there is also an evolution in enforcement. I have not managed to raise these issues, but several panels have, and we could go further in the discussion if you wish. There is the rise of monitoring as a mechanism to both prevent and to address fundamental rights violations, which is meant to happen both through EU agencies, but as well through new national independent mechanisms that are meant to follow these new screening and border procedures that I mentioned. There is greater steering from the EU institutions. They have great roles in, as I told you, identifying pressure, identifying solidarity needs, activating derogations in terms, allowing member states to activate derogations in terms of crisis. So they steer policy implementation much more closely and influentially. And all this can bring tension and complementarity with traditional enforcement. For example, the enhanced role of the European Commission as a coordinator / joint implementer on the ground has also brought a certain reticence, for example, in pursuing infringement proceedings. Of course, it is within its discretion, but that it exercises this discretion in a way that it does not actively pursue infringement proceedings in this area. And there is also the shadow of externalization. Again, I won't go into all the details, but all these pact measures have come as well with an increasing focus on return and on externalization. We have already a proposal for a new return regulation. We have enhanced safe third country provisions within the pact that might be further enhanced through a pending proposal for the moment. And more broadly, migration is weaved into the EU's external relations through this kind of whole of government approach deals, which make a far-reaching policy linkage between everything from macroeconomic stability, digital transition, labor, migration, etc., underpinned by funding, this kind of soft, informal frameworks. There have been recently such frameworks with Egypt, with Tunisia, with Mauritania, with Jordan. So we see a focus on such, let's say, developments. So I will stop here. I just leave on the screen also two series of publications. The one is a series of blogs on the new Pact of Migration and Asylum that I had the pleasure to co-edit together with professors Daniel Tim and Iris Goldner-Lang, who were actually at this conference last year. And the second is a policy book that I co-edited with two colleagues from the European Policy Center, Alberto Neyhart and Elena Hahn, and it contains different contributions, among them one from Andreina De Leo, who is here in the conference and speaking tomorrow morning on externalization in Italian for those who wish to follow. So thank you very much for your attention, and I look forward to your questions.
Thank you, Professor Zurdi, for your insightful analysis of the new pact, where you highlighted very well some of the most critical aspects of the new pact, such as how to counterbalance the enhanced responsibilities of states at the external borders, or the limited fundings, or the flexible character of the solidarity mechanism. But you also highlighted the evolutions in implementation and in governance. So we will see if these evolutions will overcome some of the traditional shortcomings in implementation of EU policies on migration and asylum. Thank you very much. Now I turn to Professor Jürgen Bast. Was title of this presentation is Restricting the Free Movement of Asylum Seekers, Human Rights Limits of EU Border Policy. Please, the floor is yours. Yeah, of course.
Hello. Welcome, everybody. Thanks again to the invitation by the organizers. Thank you, Mario. Thank you, all the other, for your hospitality at this faculty and for the opportunity to talk to you today, and thank you for the kind introduction. I've been talking to a much more learned colleague yesterday, and he said, you had to start with a story. You cannot just start with something. And he said, oh, I once played guitar. I'm not able to play guitar. I present you a picture. And what's the purpose of the picture? Well, sometimes when academics play party games, they play, what's your famous fictional character? Okay, I would like to play with you, what's your famous legal fiction? So, because my talk will be about legal fiction, or something which people tend to refer to as the fiction of non-entry. And that's my famous legal fiction. Okay, that's what you see here is above the 62nd parallel, so in northern Scandinavia. It's a random picture taken from the internet to make my point, because, well, what do you see? Well, my point is, essentially it's flat, isn't it? Yeah. Legally speaking, these are mountains. This is a mountain area. And that goes back to the first accession of the European Union, at the time European Economic Community in 1972, the northern expansion, where also Norway was negotiated in Sweden and the UK and Denmark came to. And at the time, the European Union was a completely different animal. It was not dealing with so important issues such as migration, but rather with agriculture. And there was a very developed, elaborated scheme of redistributing money, among other things, to mountain farming. Because it's quite difficult to do farming once the slope had a certain degree, and it's difficult to raise crops there, and maybe you can only have sheep and things like that, and therefore mountaineering farmers received additional funding, for example, in the Rhône in Germany or in the Central Massif in France. But when the northern countries entered, they had the difficulty that France insisted that there should be no renegotiation of policies that had been and simply applying the scheme of mountain farming wouldn't give them anything because of the ice age. It's essentially flat in the northern Europe, and therefore, in the Act of Accession of 1972, there was the introduction of a legal fiction, which is still in place until today. When the European Union speaks of mountain areas, this includes areas north of the 67th parallel. That's my famous legal fiction. To draw just your attention to this talk, that has no particular purpose other than you remember me and have particular interest in what we are going to do. So what is my actual topic? It's the asylum border procedures, to which many refer to as a fiction of non-entry. I will get back to my personal opinion as to whether this is an actual correct definition or understanding at the end of this. My main argument is that this policy, this asylum border procedure that has recently been introduced and will take effect roughly 1 year from now as a mandatory policy for the member states, actually interferes with the human rights, namely with the right to liberty of movement laid down in a protocol to the European Convention of Human Rights. I will develop, let's say, a doctrinal argument. I would say that interferes with this particular right. Just to briefly mention the context of my talk here, that emerges from a more broader research projects, actually a research group of 10 PIs and several postdocs and PhD students. That's the ADiM-IntoME project, Human Rights Discourse in Migration Society, and our core interest is to understand the process that we call human rightization, a process that is driven by the fact that actors in migration society, be it in a legal context, be it in political context, be it in situations of the everyday, refer to human rights to make their claims in migration-related conflicts. That's something which we would like to understand in this project, and in particular, what I'm presenting here has emerged from one of the legal sub-projects of which consists of 3 researchers. One of them is me, and 2 PhD students. Why do I mention that so specifically? First, I would like to draw your attention to this project at all, so you can follow us on social media and come to the conference from 1 year from now. But, well, honestly, I would like to recognize that Some of the thoughts I'm presenting here actually emerge from the work from these PhD students, so that it's accredited also to them. Okay, what is the structure of my talk? I will very briefly, because you did a wonderful job in already introducing that, explain you what the essence of these asylum border procedures are, which the European Union is going to introduce. And then I will look into, first, what the Refugee Convention, the Geneva Refugee Convention of 1951 has to say about freedom of movement of asylum seekers. And then secondly, I will look into the protocol number 4, and then to the extent that it does exist, into the case law of the European Court of Human Rights on the particular provision on free movement within the territory of a state. And well, I will conclude with some conclusions, including my personal opinion on the fiction of non-entry. Let's get started, and I will expect you to, at some point, also read with me, that's a warning, read with me highly complicated provisions and try to make sense out of them, starting here. So I'm quoting actually from the Asylum Procedures Regulation. So what's the overall approach of the European Union in the Asylum Procedures Regulation? There's one core element of continuity, and we should acknowledge that. In particular, in light of other regions and states where this is different. There still is the right to claim asylum at European borders. And that gives you access to the territory of the European Union. You have a right to remain on the territory of the European Union while your asylum claim is being processed. Look at the US-Mexican border, it's different. So we should value that. So there's an element of continuity, but there's also something new that is the subject of my talk, namely following a screening, persons are being identified, asylum applicants are being identified, whose application is being processed in this asylum border procedure. There are different categories, I will not mention them now. Just to keep one point in mind, falling into one of these categories sometimes is the result of your own behavior, of your own actions, so you can control it as an asylum seeker. But at one crucial point, this is not the case. There's a category of asylum seekers, a certain class of asylum seekers, where you cannot avoid falling into this border procedure. And this is actually one of those asylum border procedures where the member states have no option as to whether to apply this procedure or not, where it is mandatory. That is, where the statistical chances of success of your co-nationals from where you are, the success of previous asylum applications being accepted determines as to whether you fall into the asylum procedure or not. And the union-wide level is 20%. So you have no chance of circumventing that, whatever your behavior is. So that's maybe also legally important. Okay, are these border procedures described? I highlighted some terms in red, first to help you get the core statement of the sentence, but also to identify that there might be a tension between these various statements. So, getting back to the first bullet point for a second, I repeat, literally, that's a term taken from the Asylum Procedures Directive, all asylum seekers, including those who are subject to a border procedure, have a right to remain, They are not illegal immigrants. They have a right to remain on the territory pending the decision on their application. Therefore, it comes as kind of a surprise, maybe, that the Article 43, paragraph 2 of the Asylum Procedures Regulation seems to state something different. It says, applicants subject to the border procedure shall not be authorized to enter the territory of the member states. That comes as a surprise since they have actually has entered. They are on the territory. By very definition, these procedures take place on the territory, and you cannot avoid having entered when you are on the territory. At least if entering means having crossed an international border. This sentence only makes sense if enter seems to mean something different, or the emphasis may be of authorize. Maybe you're still not, you're entered, but you're not authorized. Difficult to say. But so you're on the territory, but you're not authorized to enter. And then it continues, Article 54, paragraph 1, it says, well, there's a duty imposed on the member states to do something, namely to require the applicant to reside. There is a residency requirement which the member states must impose on the applicant. So it's a state. The provision itself is directed to the member states, so it's not self-enforcing, but the member states must impose an obligation on those who are assigned or who are subjected to the asylum border procedure, namely to reside, and then there are several alternatives, difficult to figure out, but they have something in common, namely they are locations within the member state's territory. Once again, the emphasis is it's on the territory of the member states, and on that territory there are several locations in which the applicant has to reside. These are either at the border, locations at the border, or in proximity to the external border, or by way of exception to a general rule, also at other geographical places which are not at or in proximity to the external border. But the general rule is to simplify the statement, you have to stay put at the border, at some location which you must not leave. So that's the general idea. And well, that imposes, that raises, human rights question. And the entire discourse, as we have observed in ADiM-IntoME, obviously several times, as usual, so to say, human rights are the main normative resource on which critics of this migration policy refer. But here's an interesting observation, or one that I find interesting. Almost exclusively, almost always, is reference being made, those actors who argue with human rights refer to detention, to prohibition against arbitrary detention. And they are right. So the entire thing cannot function without detaining a person. The entire idea that you must not leave, so there must be some force behind it. Okay, and the argument is right. Either member states must use detention in the legal sense in order to ensure that people respect this residency requirement, or they impose something which is not technically not called detention, they call it differently, they use other means, but legally speaking, it quite often will amount to detention in the legal sense. And then it's de facto detention, and usually then it's pretty easy because detention comes with procedural requirement, and de facto detention actually has never observed this procedural requirement, then it's illegal in the first place. Those people who refer to detention are right. That's one of the core human rights issues which this thing raises. But then there's the surprising thing, and that triggers my talk today. I will stop at this point here to talking about detention, although I recognize it's important. It's maybe even more important than what I'm talking about. But I would like to talk about something else. Namely, What is the legal situation in terms of human rights in a situation where a restrictive measure, an area-based restriction, does legally speaking not amount to detention? And they do exist. Being confined to a small Greek island of a particular size is not necessarily detention. But you cannot leave. There's not even a ship. So that's physically impossible. Also, it's legally forbidden. So people are imposed, restricted on a particular area, a small Greek island, but it's not detention. And exclusively focusing on detention as a normative claim why this raises an issue of human rights has the downside, the discursive downside, of somehow giving the impression, if it turns out that it's not detention, it's just fine. There are no limits. If you exclusively talk about detention, you give the impression that area-based restrictions that do not amount to detention are beyond human rights limits. And the remainder of my talk today will argue against that point. So I'm talking about area-based restriction, which are legally speaking not detention. So, okay. One of the resources where this human right to freedom of movement, to liberty of movement may be derived from is the Refugee Convention. Well, what is the legal status of the Refugee Convention in the Union legal order? As you might all know, this, according to Article 71, paragraph 2, it has a constitutional status. The European Union, although is not a state party to, or not a party to the convention, but it had bound itself on the highest level of its law to observe the Geneva Convention, and therefore it's incorporated on the constitutional level. So when we find out that these measures would violate the Geneva Convention, we automatically say it's unlawful under EU law. So it makes sense to look into the Geneva Convention. Well, there are two provisions. I gave you the almost entire wording here. There are two provisions that deal with freedom of movement that may apply to asylum seekers, and it's incredibly complicated to make sense of them. And if you look into the literature, there are so many different opinions about how they should be construed and what their relationship is. It's actually clear that 31 paragraph 2 applies to the situation of first arrival. So that's the first phase. Most people say it's not, when you illegally cross the border, you're not under the coverage of 31 paragraph 2, but at the very moment you are registered. So everybody is in agreement then. And it must be necessary. There's a necessity requirement imposed on the convention states when they restrict access to the entire territory. So that may translate probably in EU law into the principle of proportionality. So that has also a backing in the Geneva Convention. But then again, this ends when you are regularized, or by way of reference in paragraph 1, when you are authorized. What does that mean? In our case, are people who are registered after the screening process and assigned to the asylum border procedure, are they regularized, authorized? Some people argue that gaining the formal status of an asylum seeker and your application is being processed, you are under, so your status of this first arrival ends and you have a higher status of protection. That is Article 26, the second provision. Most people doubt that. Since Article 26 says you have a very strong claim of freedom of movement within the territory when you are a refugee who is lawfully in the territory. What does lawfully mean? There's a highly complex system of the Geneva Refugee Convention. I will not even try to explain that here. James Hathaway is the champion who first really systematically developed the idea that the Geneva Convention is built on the idea of a graded system of acquiring rights. Some rights even apply before you arrive or at the border, that's non-refoulement, and others require time or legal events. And in the language of the Geneva Convention, being a lawful refugee is quite progressed. That usually seem to refer to people whose status determination procedure is being concluded already. And that means the strong protection of 26 probably will not apply to asylum seekers, and at least probably not, even more probably not to people who are asylum seekers and assigned to the asylum border procedures. But it's subject to debate. There is no centralized authority interpreting the convention. Other people have different opinion about that. But it seems to me that the stronger legal arguments can derive not from refugee law, but from human rights law in a narrow sense. And here we have protocol number 4 to the European Convention of Human Rights. What's the legal status of these protocols to the European Convention of Human Rights? Well, they are part of the body of human rights of the European Convention, and therefore they are regarded as the main source of inspiration for interpreting the Charter of Fundamental Rights. But here we have a problem. Actually, the provision of Article 2, paragraph 1, which is reproduced here, has no mirror provision in the Charter. Almost all provisions of the Convention have their corresponding provisions in the Charter of Fundamental Rights of the EU, but that one has not. Difficult to explain why. Maybe the reason is that Greece has not signed and ratified this protocol. So they were maybe uncertain as to whether this is actually should be part of EU law. But then again, we have settled jurisprudence of the European Court of Justice that in order to rely on a second source for fundamental rights in the EU, namely the so-called general principles of EU law, it's not necessary that every single member state has recognized that. He has, in Mangold, he has said there's a prohibition on the discrimination on age, although only 2 member states had that in their constitution. So I do not doubt that Article 2, paragraph 1 of Protocol number 4 has the status of a fundamental right in EU law. When I'm able to demonstrate, if you believe me, that asylum seekers are covered by the protocol, you will believe me that it's part of EU law, I'm sure. Okay. But then the problem is, do asylum seekers actually fall under Article 2, paragraph 1? Which says that everyone, okay, asylum seekers are everyone, lawfully within the territory of the state shall have the right to freely move within the territory. That almost literally repeats the provision of the Universal Declaration of Human Rights and of the International Covenant on Civil and Political Rights, which was actually drafted later than the protocol itself. So we have that in universal human rights law, and we have that in European human laws, but the very idea that's a fundamental right to freely move within the territory in which you lawfully reside. Are asylum seekers lawfully residing? That's up for discussion. I will come up with the main legal argument in a minute. What will be the consequences once you say yes, asylum seekers are lawfully within the territory of the European Union, and including those who are subject to a border procedure? The main consequence is, well, that any restriction on freedom of movement within the territory must be in accordance with law. There's a legal basis requirement, and you violate, if it not even complies with domestic law, then it violates the convention, okay? That's not so strong the point, but there is a proportionality requirement, and here it's a stronger one. It's the one you know from Article 8. Is this necessary in a democratic society in view of a certain limited number of public interests, of legitimate grounds? The core provision of which is ordre public, public order. But it's notably not any public interest which is sufficient to restrict the freedom of movement. So mere administrative convenience would not suffice. We have jurisprudence on that from committees and also from the Court of Human Rights. Public interest is the broader concept that the European Union finds it nice to keep these people put because it's easier to deport them afterwards. That does not suffice. And having filed an application, the chances of success of which are minus 20%, I don't buy that this is a requirement of ordre public. Yeah, that's nice for the European Union, and it has certain policy goals. You explained that to us, what the governance idea is. But falling into a particular class of asylum seekers does not subject you to human rights limitations. That's my core argument. So it will be difficult, at least at the level of legislative balancing. Obviously, in an individual situation, imposing that restriction may be legitimate. But this is the Article 8 requirement of finding a fair balance, and arguably that needs to be looked into on a case-by-case basis. And this is actually different from what the European Union says. The European Union defines, the European legislator has defined certain classes of migrants which fall under these restrictions without any discretionary decision making. And therefore, although the outcome is not determined, an entire new field of making claims and arguing cases is opened up when this provision is applicable, provided that this provision is applicable. I did my proper research. There's one case. And of course, in the European Convention, one case doesn't make a summer. But in particular, when it's from 2007, and the facts of the case even predate the Europeanization. But look into the language, what the European Court of Human Rights said. Let me first explain the facts of the case in order to make you understand how closely it resembles what we today call European asylum border procedures. It was a person with an Aufenthaltsgestattung, one of the different names which the Germans give to a residence permit. So, the Aufenthaltsgestattung is the legal status of an asylum seeker once the person is registered. It's exactly what we're talking about, registered asylum seekers. And even today, it's still called Aufenthaltsgestattung. That was the fact of the case predated the Asylum Procedures Directive, but the Germans didn't change anything. They hand down to an asylum seeker the Aufenthaltsgestattung, which is actually, in this case, the directive is actually modeled after the German concept. Okay, so it's directly applicable to asylum seekers. And German policymakers had at the time, and actually still have in many instances, the policy of restricting the movement of asylum seekers. In this case, not at the external border, because Germany, apart from the international airports and some tiny fractions of the Baltic Sea, does not have external borders. Okay, fine. But at the county where the people are living, in the city or in the region. They must not leave that without permission from the alien's authority, otherwise they get fined. Yeah. So there is a residency requirement which, according to German courts, does not amount to detention. That's plausible. Exactly the situation we're talking about. Residency requirement of asylum seekers. What did the court say? It did come up with a strange solution. Have you read it? It's crazy. Okay, first of all, it says that is settled jurisprudence. This lawfully within the territory must be read as a reference to domestic law. So domestic law, not the convention, defines who is lawfully resident, lawfully within the territory. That makes sense. In this case, it was the German legislator. In our case now, it's the European legislator. It defines the legal status. So we must look into the Asylum Procedure Directive. What does it say? Are these persons lawfully within the territory? Well, do you remember the red words which I gave you? Right to remain? Doesn't sound unlawful to me, actually. Yes, they are not authorized to enter. Okay. When asylum seekers leave the location to which they are assigned, to which this residency requirement applies, then, so the court says, then they move beyond what the national legislator or the domestic legislator, in this case the EU legislator, has granted you. So as long as this person at the time remained in the particular city, he was lawful within the territory. At the very moment where, actually it was an activist and wanted to organize a conference in another part of Germany, and the authorities didn't give him a permission for that. At the very moment where he did so anyway, he was not lawfully within the territory anymore. And therefore this strange, so long as they comply, they are lawful within. Strange outcome. That means that in asylum, if we apply that to the European asylum procedures situation, so as long as persons remain within the location at the border, at the proximity at the border, or exceptionally at the other geographical location assigned by the member states and notified to the Commission, they are lawfully within territory. And then they can legally claim a right based on Article 2, Paragraph 1. So, difficult to make sense of that, but I understand it to mean the convention does not have direct effect. You have to comply first, but you can raise a claim. And as long as you remain within the location, you have a human right, which triggers a requirement of justification. The member states, or maybe the European Union, public authorities have to come up with a justification of keeping these restrictions in place, based on the grounds in Article 2, Paragraph 3 of the 4th Protocol. And then a fair balance has to be struck. So, not in every case will this be unlawful as a result, but as long as asylum seekers comply with the residency requirement, they can make a human rights-based claim, and member states and or the European Union has to justify keeping the restrictions in place. I think if that is the law as it stands, it makes quite a difference as to whether there is a human rights limit to area-based restrictions that do not amount to detention. This is my conclusions. My conclusions say, asylum seekers in the European Union do enjoy a right to freely move within the territory of the member state in which they have the right to remain pending a decision of their applications. There is a human right. And the personal scope of these human rights, and by implication for EU fundamental rights, includes those applicants who are subject to the asylum border procedures. as long as they comply with the requirement to reside in a designated location that is drawn from the case law. And accordingly, as a consequence of that, any interference with these rights must be justified on one of the grounds listed in Article 2, Paragraph 3 of the 4th Protocol to the European Convention of Human Rights, and must comply with the principle of proportionality. And it's up for another talk to argue as to whether legislative balancing is possible in this respect, or whether this implies, as it does under Article 8 in expulsion situations, a requirement of an individual decision-making in a case-by-case assessment, in which case, at minimum, the statistical chance of success clause would violate EU fundamental rights. So as a result, coming back to Northern Scandinavia and my famous legal fiction, well, I would argue that describing the asylum border procedure as a fiction of non-entry tends to obscure the legal situation. Namely, that the applicants are lawfully within the territory of the European Union, in this case of the border state, and can therefore make a claim they can claim a conditional right to move to other parts of the territory. Conditional means restrictions can be justified, but need to be justified. And my formulation here, they are prevented from moving to other parts of the territory. That is actually my rephrasing of the actual meaning of what the Asylum Procedures Regulation in legal substance says when it reads, they are not authorized to enter the territory. That means enter other parts of the territory without authorization, and therefore it doesn't make sense to call it a fiction of non-entry. These people have already entered, and it's about restricting or not their freedom of movement within the territory, and therefore, if we want to be legally precise, we should not call it a fiction of non-entry. Thank you.
Thank you, Professor Bass, for the stimulating presentation, where you showed complexities in distinguishing between detention and other formal restrictions, but you also showed that these other forms of restrictions are not in a legal vacuum, but there are some human rights legal standards. So we can now open the Q&A session, so we can start collect some questions. I have some, but I will give the priority to the audience. There is...
So, good afternoon to everybody. Thank you for both presentations. They were very inspiring. I am Camilla Galitz, postdoctoral researcher from Sant'Anna School of Advanced Studies from Pisa. And I have one question for each of the speakers. First of all, I have a question to Professor Zurdi. I really enjoyed your presentation, and it just confirms what you have written in 2021 about the increasing trend to read together the different pieces of asylum law. And in light of another writing of yours about the rule of law backsliding in the EU asylum field, my question is, given the adoption of the pact, how does the new pact impact the EU's constitutional structure in light of the rule of law backsliding? So how would you update, let's say, your opinion written 4 years ago, sorry. And to Professor Bast, I have a question regarding the joint communiqué published last week by a couple of Council of Europe member states, including Italy, regarding the need to revise the European Convention on Human Rights in the context of new challenges presented by the complex migration process or whatsoever states in the communication as regards this vogue reason to revise. So what is your opinion about this need, and how do you interpret the future perspectives of member state compliance with the European Convention? Thank you.
We may collect some, if there are some other questions, otherwise, okay, Professor, okay, Professor Savino.
Thank you very much, Lilian and Jürgen. I did a very good job in selecting you. I'm very proud. Now, both the interventions were very thoughtful, and I really thank you for these. Let me start with Jürgen and his really intriguing reconstruction of limits to the freedom of movement. I was reading Article 45 of the EU Charter on Fundamental Rights, which is framed in a different, Article 45 of the EU Charter, which says it's different, and the wording is really crucial, right? And I like very much the fact that you were using the text in order to explain how we can interpret them and take them together in the picture. So according to Article 45, every citizen of the Union has the right to move and reside freely within the territory of the member state. So every citizen. Then the second paragraph adds, freedom of movement and residence may be granted in accordance with the treaties to nationals of third countries legally resident in the territory of a member state. So, of course, we are more interested in the interpretation of the second paragraph, which says may be granted, provided that they are third country nationals that are legally resident. So we have, again, the issue of who is legally resident, and still we have a may be granted. So my first question is, how do we reconcile the idea that you're suggesting that, I mean, according to your interpretation, if I'm not mistaken, Article 2 of Protocol 4 of the European Convention would set a higher standard in terms of protection vis-à-vis the EU Charter. How do you square the circle here? And of course, the border procedure is very problematic in many respects. I mean, just to add to your discussion, we have Article 13 of the Constitution on personal liberty that says that it can only be limited on administrative basis, provided that we have a specific law that foresees this possibility as very exceptional, only in specific circumstances. And one might want to argue whether, ascertain whether this is the case with the border procedure we foresee, for instance, in Albania or in general in the Italian territory, where there are alternatives to detention, but the likelihood that asylum seekers can really enjoy those, can really get advantage of those alternatives is very, in concrete terms, is very remote. So let's say the rule is detention for those who come from, say, third countries, rather than the exception as required under Article 13. So a lot of constitutional problems will arise in this respect. Some questions also to Lilian. One is a minor one, but still, do you have any clue about why the European Commission is not allowing access to the national implementing plans that have been collected in the last few months from the member states with regard to the new pact. Because as far as I know, many NGOs, and Emilio De Capitani, I guess you're familiar with him, try to obtain access to those plans, and then the answer was negative, and I just wonder why this implementation process is so opaque. And then on adequate capacity, what if a member state does not meet the ceiling or cap provided for under the label adequate capacity? Do you foresee the likelihood of the Commission launching an infringement procedure? And if not, what is the political administrative meaning of that notion? I'll stop here.
Maybe we can start answering, and then who wants to start? Professor Zurdi, want to start? Okay.
Many thanks for your questions. Thank you for also engaging with my previous scholarship so thoroughly. So in that piece in 2021 in the EU constitutional law, I had reflected on how we can look into human rights violations in the framework of migration management, so human rights violations of member states as rule of law failings. So what has happened 4 years later, and also how the pact influences this. So I would say that there has been an ambivalent stance by the Commission, because to some extent it has, in the case of Hungary, for example, launched what can be understood as a systemic infringement, so both an infringement on, let's say, specific aspects of asylum procedures, but also in a number of other follow-up infringements. One could see this as an understanding of systemic infringement proceedings, so seen also connecting in a way, even if not explicitly, these violations for the specific member state with the broader rule of law backsliding. On the other hand, indeed, the new setup could lead to further violations of fundamental rights of migrants. So Jürgen mentioned one of them, which could be deprivation of liberty and, let's say, unjustified restrictions to the freedom of movement in the framework of border processing. But there are also other concerns, for example, on the right to an effective remedy within border procedures and other procedures where there is no automatic suspensive effect. Now, even under the proposed return regulation, also return decisions will not have an automatic suspensive effect. So we see that other, let's say, provisions within the design could lead to further violations. So in the sense that not that the provision always itself is violative, because also within border procedures it says any restrictions or any deprivation of liberty according to the standards of the Reception Conditions Directive, etc., but that in reality it could be that expediency, speedy processing, might lead to the undermining of these standards, and thus open, especially at the borders. Also, the crisis and force majeure regulation is another instrument that brings these questions. It could open the front for generalized / systemic practices which are violative of human rights. So I would say there is an ambivalence there. Mario, thank you also for your observations and for your questions. So that's not a legal reason, but I presume that the Commission is not releasing these plans because it considers the situation to be very politically salient and sensitive, with a number of member states already beginning to resist the pact as itself being restrictive, but of course that is not a legal reason. So the only legal reason to bring would be that this relates to national security, but it is difficult to construe how a national implementation plan under the new pact actually influences national security. I can think of very extreme arguments of member states saying, oh, the exact location, I don't know, of centers next to borders, next to military facilities, but it's really far-fetched. So I would say this is, of course, the only legal reasoning. Where it is raised, I would say it is far-fetched. But the reality is that this is considered currently politically salient, and then there is a shroud of other excuses that are being brought forth. This is often the situation with national operational plans of EU agencies, which again are not released for national security considerations. So there are these complex arguments that are being made around border areas. Whether, though, that passes muster, let's say, I doubt sometimes. So in terms of adequate capacity, you are saying then what if the member state does not make it available, does not build up its let's say, its capacity? Well, certainly that would be a violation of its obligations, since now they are also numerically refined. Politically now, I do not believe that an infringement would be the first move of the Commission, especially as member states are now trying to build up their capacities, so it would be an ultima ratio. But I think if a member state ideologically, so not because of, I don't know, financial or other considerations or technical delays, if ideologically it said, as Hungary and back then Poland said, I will not participate to relocation, where in the end the Commission did bring an infringement against these two member states. If it ideologically said, I am not going to participate in border procedures, I don't know anything about these facilities, then I think it would use this weapon. But in case we were just talking about a member state that was still, I don't know, trying, etc., and just delaying, I think that it would try other means before reaching there. But that's, of course, a kind of speculative guess. Yeah.
Thank you for your question. As to the colleague from Sendana, I find it a little bit difficult to assess that politically, because in a way it's too fresh. Let's see how it plays out, how other actors react on that for the others. So it's part of a situation where some governments have chosen to openly put pressure on the European Court of Human Rights. So it's phrased differently, but I guess it's quite obvious that it's less a serious attempt of renegotiations, anything. There's no political window of opportunity for coming to a new consensus on the human rights treaty. But rather it's about how to construe, how to interpret the convention, and maybe also, as you suggested, giving leeway to more lenient or less compliance in terms of implementing the judgment. Yes, that's true. I'm not so sure whether this is so dangerous as it sounds, but I'm cautious. That by brute force you do not convince judges. So that's too what's plump in too crude. So that's simply not sufficiently sophisticated how how they do it. I would hope for that. But unfortunately, meanwhile, more subtle and potentially more effective means of putting pressure or influence in the jurisprudence of the courts are underway. So, including selection of judges, that's a more political level. But one of our ADiM-IntoME projects is actually focusing on governments as doctrinal entrepreneurs. So, how government, by way of what they call reverse strategic litigation, try to influence the way how human rights jurisprudence develops. And that might, at the end of the day, be more effective being a smart actor in the courtroom rather than making that type of statements. I hope. As to Marius' two questions, the first one is a doctrinal one about EU constitutional law. I thought about the point you're raising. That's why I find it easy to answer for that. The second one, it's more difficult for me to answer. As to the meaning of, or the impact or the significance of Article 45 of the Charter for my legal argument I made, I would not entirely share your representation of the meaning of the second paragraph, so which is the crucial one. It's talking about third country nationals. The second paragraph actually does not contain any fundamental right. It simply restates the very existence of legislative powers of the EU legislator to grant a statutory free movement. Yeah, that doesn't withstand the blue pencil test. So the legal word is not different if you cross it out. So actually, the Charter of Fundamental Rights does not contain any statement on therefore also not any right of third country nationals to freely move within the European Union. The Charter is simply silent on that. Therefore, your argument of is that the higher standard thing, I don't think it's entirely accurate. I guess it's about gaps. So the Charter doesn't say anything, does not grant any rights on third country nationals in terms of their free movement within the European Union. While we are not talking about free movement within the European Union at all. That's an argument for another talk. What follows from my point today for the territorial entity European Union? But that is based on highly critical premises as to whether you regard the European Union as a territorial entity, which by implication would also be bound with respect to its entire territory to justify restrictions of movement. We're now talking about something which the Charter is completely silent, namely the free movement within one member state. And then we have a situation where, which has popped up several times in the jurisprudence of the Court of Justice, namely that this type of gaps may be filled by general principles of EU law, the much older source from which fundamental rights in community law has been derived, by having recourse to treaties that member states have signed and ratified or common traditions of the member states. And seriously, something which is in the universally ratified, say for China, universally ratified International Covenant on Civil and Political Rights. That is certainly part of the common traditions of the member states, and it's one of the many treaties, one of the treaties which the European Union has signed, and therefore it is actually the very same situation like we have in one of your field of specific expertise, namely administrative law. There's a right of the defense, also with respect to the member states, although the right of the defense are only mentioned with respect to union institutions and bodies. So it's based on general principles of EU law as it was before the Charter entered into effect. So the crucial issue where you have to kill me is on the level of international law. Once you buy that, you have no chance but to respect that it's also part of union law. I'm highly convinced of that. As far as immigration detention as a constitutional challenge is concerned, I have to admit that I'm not really an expert in that. I always observed that the Commission, and then by extension also the EU legislator, has taken a very strange Pontius Pilate approach by all the time repeating, oh, we don't require the member states to use detention. We don't say that. So it's up to them, and when they do, they have to meet all the requirements which fundamental rights and human rights, actually fundamental rights are stronger in that regards, apply, but we don't say so. It's a typical kind of what we call in the REMAP study the under-exclusive legislation. So it doesn't force member states to violate rights, but it tacitly invites them to sue by not preventing them from doing that. If you look into the supposedly legitimate ground on which detention may be imposed according to the Reception Conditions Directive, it crassly violates human rights standards. But it's not unlawful under EU law because member states could lawfully implement that by simply only doing so when it complies with fundamental and human rights, and therefore Pontius Pilate. So we don't force you to violate. We only invite you to do so. That's the legal situation, which is difficult to address.
Thank you. Are there other questions? Otherwise, okay, there is another question. I think the last one, I would say. Yeah.
Working? Oh, I think so, yes. Thank you very much for those insightful presentations. My name is Maja Łysienia. I am a postdoctoral researcher at the University of Lausanne and University of Applied Sciences, Western Switzerland. I have one comment and one question. One comment concerns implementation plans, which were actually asked about previously, to maybe give you some very particular national context in this respect. I originally come from Poland, and Poland basically did not share implementation plans with NGOs, did not consult it with NGOs, despite NGOs being very eager to do so, denied access to any information what is planned. And actually, my prediction in this regard is that Poland could have communicated also to the European Commission that they are not agreeing for their implementation plan to be publicly available. And the other guess here, in this respect, also Poland is quite against some solutions, as you mentioned, Professor Zurli, to some solutions in the new pact, and I guess the implementation plan reflects that. And for that reason, European Commission may not be so eager to make it public, to show that actually from the very beginning it will not operate as it was supposed to operate. That's the comment. Question concerns this to Professor Bast and his very interesting approach to fiction of non-entry. It's really intriguing, and I really like it, how you approach the fiction of non-entry by saying that it is actually not a fiction of non-entry. The only problem I see with this concept is that member states, I don't think, see it the way you do. And to go back to Polish example, Poland for many years has been forcing on the European Court of Human Rights the fiction of non-entry in the cases concerning border borders and denials of entry at the official border crossings like MK and others versus Poland. That was their argument. We didn't, there was no jurisdiction because those people were never allowed to enter Poland, so there is no jurisdiction. They were not on Polish territory, despite that they were at the Polish border checkpoints on the Polish territory. And European Court of Human Rights under Article 3 of the Convention and under Article 4 of the Protocol number 4 denied this argumentation, never agreed to this kind of argumentation. So if the states see this fiction of non-entry as really a fiction of non-entry, how we can use your idea for the strategic litigation? Is this idea for the lawyers to question what the states will be doing with the new pact? Is it the idea for the European Court of Human Rights how to approach what will be happening on the borders very soon? How we can use it? How we can use it?
Thank you. Professor Bast, do you want to start? And maybe then if you want to react to the comment. Okay, so. Okay.
Thank you for your question. This fiction of non-entry thing has, as I learned from, in particular from reading draft chapters of the PhD of Anna, a PhD student in this Teilprojekt, Anna Arden, has a really long history that goes back to the 1980s. That was actually the time when it was probably invented in legal struggles over policies invented by the French government in terms at the airport Charles de Gaulle at the time. And some people of you may know that, although they do not do a PhD on airports, because it, at the end of the day, resulted in a very famous judgment, namely Amour. Or is it Amour? I don't know. So namely the judgment where the European Court of Human Rights said, well, the fiction of non-applicability of human rights law in the transit zone of an airport is immaterial. It's not possible by making national determinations on waiting zones to non-apply human rights law. That was a rather early element of human rightization of migration discourse, and the court was confident to say so because French administrative and constitutional courts had previously said so for the French constitution. They had killed these particular policies where France had tried to argue this airport transit zone is not part of our territory. So similar to what the Polish government is arguing, and therefore that's a lost battle. I mean, they lost Amour, that was, I guess, beginning of 90s, so that's done, they have no chance. But on a more subtle level, in a much more subtle or disguised way, this fiction of non-entry arguments pop up time and again. The crude way is saying human rights do not apply at all because it's somehow not part of our territory. That doesn't work. But trying to argue that a different legal regime applies and somehow different legal standards apply, that's part of the conversation, and therefore it's so important to. I would argue, Anna has a different opinion in that regard. I would argue we should not employ a language which somehow gives justification to that. It's simply part of the territory, and union law applies, and human rights law applies, and these restrictions of movement have to be justified. And any other forms of treatment that does not accord to human rights and fundamental rights standards, for example, access to protection or fair procedures, have to be justified. So we should not buy the language of exceptionalism. Anna makes the point in saying the critical actors in these battles in France actually use this language of fiction of non-entry to criticize that. It's only a fiction. They are here. They are in France. And civil society actors such as Amnesty International and Pro Asyl, one of the human rights organizations in Germany, they actually also use the language of fiction of non-entry to highlight the fictional elements. So it can work both ways, but I'm personally not convinced that it's a useful approach if you're interested in uniformly applying fundamental rights across the territory. Then we should not buy this fiction stuff.
Thank you. I think that we can close this insightful and inspiring session. Thank Professor Zurdi and Professor Bast again very much. And so for the meeting, for the guided city tour, the meeting is at 6 at Piazza di Plebiscito, which is the main square of Viterbo. And for the dinner is at 8 at Gourmet Restaurant. Thank you.
Thank you.
Okay, sorry, for the city tour, you can leave from here at 5:40. There will be our PhD student. Sorry.
Left, it's okay.
Okay.
Okay, for tonight dinner, don't miss it because it's in a very fancy square. We will have pizza and beer together. Each one should pay, it's 25 euros just to make you aware of it. And we look forward to see you there at 8 o'clock, okay? Enjoy the tour if you go there, or the rest otherwise.